Hello. Today we discuss an important topic in relation to appointment of arbitrators. Usually we come across various agreements whereby it is written that one of the parties, of many or two, can appoint a particular arbitrator, and that person who is appointed will arbitrate all the disputes. This was in vogue for a long time, and we have all grown up in our legal profession seeing these kind of clauses being given effect to. However, now in light of the various efforts which are being made to legitimize the arbitration process, the Supreme Court in its judgment in Perkins has clearly laid down that unilateral appointment of arbitrators is not possible. Now, what does that really mean? Now, that would really mean is that one person cannot really appoint a particular person, saying that because in my arbitration clause it says I can appoint, so I have appointed, and that particular person only will arbitrate the disputes. Emphasis is now being laid on consent of all the parties for choosing a private forum. So a particular person who is chosen by the consent of all the parties involved, then that particular person can arbitrate. Otherwise, no. Otherwise, it's not possible. You will have to go to the corridor of the court, the High Court applicable, and get a appointment done under Section 11 of the Arbitration and Conciliation Act. Now, my view in this is that it is a very, very welcome change, because most of the clauses, specifically in government arbitration agreements where there are arbitration clauses, many of these finance company arbitrations, all the time it was clearly laid down that one particular party, which is clearly in a better bargaining position, will have a right to appoint an arbitrator. Now, that was extremely prejudicial to the other side. That position today has got changed because of this very welcome decision of the Supreme Court. And my friends in the bar as well as in the trade, please remember that henceforth, if there is a question of an appointment of an arbitration, even if the clause does say that one particular party can choose, that part has to be disregarded in light of the Supreme Court judgment. There has to be consent from both the parties, and the party who otherwise does not have a right to choose in the agreement does not have to bow down. It can clearly say, no, I do not agree to this arbitrator, I am going to the High Court. Or if you want, you have to go to the High Court. This particular person cannot go on with the arbitration. Please remember this. It's a very welcome change and a very new change. And many of the High Courts have recognized it, and it is being taken up. Thank you, and thank you.